Great, thank you. So hi everyone. First, thank you for inviting our office to speak today. The Attorney General extends his thanks and wanted to apologize that he couldn't be here. But like they said, I am certainly the next best thing. I don't know that everyone would agree with it. My parents would. But thank you for having us, truly. We appreciate the time to connect and to share with you a lot of the work our office is doing, both as relating to higher education and otherwise. So as I said, my name is Abigail Durkin, and I am an Assistant Attorney General within the Special Litigation Bureau of the Office of the Illinois Attorney General. I received my undergrad very close by in Champaign. My brother actually went here, so as I mentioned, I'm happy to be back in Bloomington. And then I received my JD at DePaul in Chicago. My legal background is quite litigation heavy, specifically in the field of employment law. I started my career in private practice, working on employee side litigation, and then after a few years in private practice, I decided to move over to the government. I came to the government because it felt like the right thing to do. It felt like, how can you help the most people and have the broadest impact? So I've been here for about 5 years, first in employment law, doing defense side work, and then about 3 years ago, I moved over to special litigation. Special litigation really gave me, the opportunity to work on bigger, more wide-ranging projects that have a substantial impact on the public. It's a very wide spectrum of work, but for the past couple months, which is what I'm going to focus on, it's focused primarily on maintaining the rule of law, which is a phrase you're going to hear me say quite a bit, and ensuring federal accountability. So I'll share some details about that just in a few moments. So I want to first just provide a quick overview of our office, what we do and who we are. So again, I work for the Office of the Illinois Attorney General. The Attorney General is Kwame Raoul, who is the Chief Legal Officer of the state. What does that mean? In legal actions, the Attorney General's office represents the state of Illinois. Now, the Attorney General is responsible for protecting the public interest of the state and its people. And this could look a couple different ways. It could include advocating on behalf of the folks in Illinois, legislating for new laws down in Springfield, or litigating to ensure laws are complied with. We don't bring lawsuits on behalf of individuals or individual organizations. Again, our client is the people of Illinois. We represent all of you, not individuals. We cannot and do not provide legal advice, and as any good lawyer does, I do have a disclaimer for today. As I talk today, I cannot comment on legal strategy or certain pending legal actions or investigations. So now I do want to shift to the work, to what a lot of our work lately looks like, at least in special litigation. So I mentioned protecting the rule of law. That's a big phrase. You're going to hear me say it a lot, but it really does mean something. I mentioned this was a major focal point of my work lately, and I want to stress that it is my work lately, but it's always an undercurrent of what we do. Our office's responsibility is to protect our state and the rights of all Illinois residents, regardless of who occupies the White House, and we will continue to do that. Very, very commonly across many different administrations over decades, we work in partnership with many federal agencies. We seek opportunities to do that whenever possible. Now, obviously, President Trump was elected, and as elected president, he can seek to implement his policies that he campaigned on and the policies he supports. Of course he can. The Attorney General has been clear that President Trump, of course, has the right to do that. That's not our issue or the point of our recent work. As we mentioned, he is entitled to set forth the policies that he desires. But the point to that is that though President Trump is entitled to implement his policies, he must do that in a lawful way. That means a way that is consistent with the Constitution and the laws that Congress has enacted. That is not an option, and that it really shouldn't be an option. Now, unfortunately, the president and his administration have chosen, with many of their executive actions, to ignore the Constitution and the federal law, and that has significant consequences. And it's cause for significant concern, and it affects truly all of us. but how does it affect us? Sometimes it just feels like the news, and we have to think, how does this impact me? How does this impact Illinois? And what do we as an office and the chief legal officer think about? And what do we consider when something happens? What can we do? These are complicated questions. They seem simple, but they can be pretty complicated. So when these actions impact the state of Illinois, our office considers the best way to respond. That can look a few different ways. Those actions can include speaking out against an unlawful action, issuing a press statement just to alert the public to their rights, supporting other organizations or individuals who are filing litigation, collaborating with state agencies that are throughout the state, or filing lawsuits directly challenging those actions. Now, one thing that's been interesting as to how this has unfolded is a lot of the impact that we feel in Illinois is not Illinois specific. We are certainly not an island. The impact that's felt here is often felt elsewhere too. We often share the same concerns and the same harms. That's why many statements I'm sure you've seen lately, or many lawsuits, are not just us, but they are groups of states working together. And those states fluctuate depending on who has a harm, who doesn't have a harm, who may have a cause of action, who may not. So we are, as the office, are in daily contact with the offices of other state attorneys general across the country to collaborate and to determine the best way to challenge certain unlawful federal actions. Speaking for myself, this is one way my work has substantially changed lately. Every day I find myself collaborating, sure, with my colleagues down the hall, but also with people from other states. It's every day I talk to someone from a different state. The same is true for state agencies throughout the state. Every day I talk to at least one or two agencies. We've been really able to strengthen our advocacy for the folks of Illinois through collaboration. So we have filed about 24 lawsuits to date because President Trump's actions or his means for pursuing his policy goals have been unlawful and in many cases unconstitutional. I will say fortunately I'm not on all 20 or all 24. And again, how do we make the determination to do something? What makes something worthy of a lawsuit? So we consider two main things when we do that. First, is the action unlawful? If it's not unlawful and it's just a policy disagreement, we don't litigate over policy disagreements. Like I said, we are looking to maintain the rule of law. So the first question, whether this administration's action is unlawful. Now, second, we evaluate whether the state has been harmed and whether, as a result of that harm, we can establish standing to bring a case in court. Now, I think it was Justice Kavanaugh that said standing is basically what is your skin in the game. That makes sense. You have to have skin in the game to bring some type of lawsuit. That can look a lot of different ways. Often, you'll see in the news, a lot of times it's financial, but certainly not always. Now, as I mentioned, many times we've joined other states in multi-state actions, and other times we've taken our own action, whether affirmative or defense, to defend or to address Illinois-specific concerns. And sometimes we don't take action, and that can be frustrating to the general public who is concerned about something and who wonders, why the heck aren't they doing something? I understand that frustration. In those cases, it is often the case that it may be that the state itself doesn't have an available legal claim. For instance, a private individual or a private entity or employer may have a better claim than the state does. And again, we don't represent individuals, we represent the whole. As I mentioned before, and we do want to stress this is absolutely not about policy differences. That's not something that we would litigate. We don't litigate simply because we don't disagree, or we disagree with the administration's point of view. We litigate, again, you'll hear me say it 1,000 times, to preserve the rule of law. So if the facts and the law aren't sufficient for us to file a lawsuit, like I mentioned, there are a few options. Taking action might look like submitting public comments to federal agencies. I did a few of those this week. Filing amicus briefs in support of other plaintiffs' lawsuits. That's the type of case where If we perhaps don't have a claim, but we are sympathetic to their cause or we agree with their cause, we can file a brief in support of them that the court may or may not consider. Another thing is issuing public statements or guidance to communicate to the public about what federal actions do and do not mean. There's been a lot lately. I can't dispute that, and it's sometimes hard to keep up. You know, I report to work every day, and it's hard for me to know even what my colleagues are working on. But the Illinois Attorney General's Office has an absolutely fantastic press team. And on our website, there is a tab called the Newsroom. And every day when something happens, or we issue guidance, or we issue a press release, or we join a lawsuit, or file a brief, they post about it in a way that's really easy to understand. It links to the document. I will tell you, I go to it 2 or 3 times a day just to learn about what my colleagues are doing. So I highly, highly recommend checking that out because it's hard to keep up on the news, and sometimes it's easy to go right to the source. So to that point, I've talked a lot about broad strokes. What are our options? What can we do? But really, what are we doing? How is our office working on behalf of you folks and on behalf of the state? And how does that impact you, your friends, your family, your loved ones? So I first want to talk to you about litigation. As I mentioned, you know, we have, I think it's almost 24, it's definitely upwards of 20 lawsuits so far, all focused, again, on protecting this rule of law and the people of Illinois. So I'm going to give you a few examples. I certainly can't get into all 20 or 24. Maybe there was one filed this morning I don't yet know about. But they can be divvied up into a couple buckets. So the first bucket is litigation protecting constitutional rights. That's one big bucket. An example of this, and this is a multi-state action, we joined other states in challenging the president's executive order that purports to end birthright citizenship in violation of the 14th Amendment's guarantee. That's not a policy difference. You know, the 14th Amendment is very clear. That's enshrined in the Constitution, and we've litigated to confirm that. I believe that lawsuit was filed almost immediately. So that's one example of that first bucket. The second bucket is a big one. It's litigation protecting the separation of powers. We hear, or I'll say I hear, the phrase separation of powers all of the time now. I feel like I'm back in 7th grade history class studying for the constitutional exam. This is a fundamental premise of our democracy. The power of the government is divided between 3 equal branches: the executive, the legislative, and the judicial branch. Again, this is really bringing me back to social studies. So why is this separation of powers important? You know, the framers of the Constitution believed this separation was important and is required explicitly by our Constitution because it protects the people against one part of government having too much power. At its core, it is purely a system of checks and balances. We've seen this type of litigation play out in a few ways. One is with spending. So again, social studies class, the power of the purse is with Congress. We have challenged instances in which that limitation, that power of the purse, has been ignored. So an example of that, we challenged a federal funding freeze resulting in the sudden loss of more than $1 trillion in funds that serve state residents. It's also come up pretty significantly in the education sphere. So we challenged the termination of federal funding appropriated by Congress for a teacher training grant program, for COVID-related education funds, for health and medical research, for public health funding. So these terminations, again, were in violation of that Congress's power of the purse. They had appropriated this money, and the administration had come in to unilaterally usurp that power. We're also seeing the ignoring of the separation of powers play out in the administration's attempt to unilaterally dismantle federal agencies. Those agencies have been created by Congress. There are statutes that create them and statutes that create the things they are required to do, their purpose, and what the amount of money, essentially, that they are allowed to spend. For example, we recently sued to block the attempt to dismantle the landmark AmeriCorps program. which provides both opportunities for public service and support for vulnerable populations across the country. And I'll speak for myself, I'm on the AmeriCorps case. Prior to being involved in this case, I knew what AmeriCorps was, but I did not see how ingrained in our country and in the state that it actually is. We really rely on a lot of these programs, and we don't even know about it. So, like I said, AmeriCorps' impact may not always be overt, but it's embedded through the country and really serves a vital purpose. And again, the linchpin here is it was created by Congress. It's not something that's optional. Additionally, we sued to block attempts to dismantle the Department of Education, as well as the Department of Health and Human Services. And these are, again, just examples. Another bucket is litigation concerning executive overreach. So under the Constitution and federal law, the president has enormous powers. Of course they do. That is why they are elected to be the leader. But again, checks and balances. In our democracy, there are limits on that power, and we have challenged instances where the administration has clearly crossed that line. Again, a few examples of recent litigation we filed. Litigation where there were new conditions placed on federal road safety and emergency disaster relief funding. These new conditions were not in the statute and were certainly not related to the underlying purpose of that federal program. We also filed litigation concerning the recent significant worldwide tariffs, where Congress was not engaged in that process. Nearly all of the cases we have filed so far are still in active litigation. It's only June, and the administration came in January, so we have been quite busy. It is a constantly shifting environment, and the pace has been remarkably swift. I do want to stress, though, that our preliminary successes have been very encouraging, and we will continue to bring unlawful actions to the courts, again, to enforce that rule of law. So this, again, is just a sampling, but what I've described is quite a lot, and it's all taken place just over the past couple months. But again, the Attorney General is the Chief Legal Officer. This is our obligation. It is our obligation to ensure the rule of law. So that was litigation. That gets the most press. It's what you see on the news. It is certainly the shiniest object in the three options that we generally have in terms of enforcing the law. I mentioned this other option, which is very, very common. Again, we can't always file lawsuits ourselves. However, we can submit what is called an amicus curiae brief. I never know if I say that word correctly, but it means friend of the court. So as Chief Legal Officer of the state, he also plays an important role in supporting the legal efforts of others who are filing lawsuits to protect Illinoisans. So sometimes, as I mentioned, we do this by drafting a quote, friend of the court brief and filing them in significant cases to explain Illinois law, Illinois' interests, in a certain important matter. Again, we may not be directly harmed, but we can see how this matter would impact other Illinoisans or how it violates certain of our laws, so that's why we file these briefs to inform the court. There have been a lot of these recently, because as I mentioned, sometimes individuals or organizations are in the best place to make a claim for themselves. But that does not mean that we are not interested. Again, I suggest you look at our website. I'm constantly learning about new briefs that my colleagues are filing, and it's very, very helpful. Again, it's the newsroom tab. So a couple examples for you. So recently, we filed an amicus supporting a lawsuit that was filed by an organization that represents individuals with disabilities, which challenged the Trump administration's action to limit the Social Security Administration. We also recently filed an amicus supporting lawsuits filed by private firms that have been targeted by the president and his administration for representing clients and interests that he dislikes. So I think we filed an amicus, and there's been certainly multiple of those suits. We filed an amicus, I believe, in all of them, but certainly for Jenner. And I do want to underscore a point I made earlier. This is not about policy. This is about the rule of law. And I think these law firm litigations and our amicus briefs in them is quite important. Many of these firms litigate against us constantly. And, that is their right. That is part of the adversarial legal system. They are entitled to litigate against us. Still, we filed a brief in support of them because that's what is important. They are entitled to do that, and it's, again, the rule of law, not policy differences. Just because Jenner litigates against us does not mean we do not support their right to do so. They have a right to do that, and we have made a point, that point in our support of their recent targeting. So another way we act, and certainly have recently, is through guidance. A lot is happening, and a lot of people have questions. So how does a certain change impact them? What do they need to know? So while our office's litigation gets much of the press attention and is in the news most frequently, the Attorney General's office also provides important explanations of certain laws for the public benefit to combat misinformation and to provide clarity in the public interest. Sometimes Google is not your friend, and we want to provide a reliable source as to what's happening, what matters, and what does this mean for you. We call these guidances, and we've issued them in several areas where the administration has created confusion about certain legal issues. So again, a few examples. We issued guidance to assist businesses and nonprofits to understand the continued viability and important role of diversity, equity, and inclusion initiatives. We also issued guidance to help institutions of higher education in K through 12 schools navigate certain educational goals and opportunities in response to various executive orders, as well as in response to Department of Ed guidance that targets diversity, equity, and inclusion and accessibility policies and programs for those schools. So again, this is really just a sampling of the work we do, and again, it is only June. There will be certainly more to discuss. As issues develop, you will see more litigation, more amicus briefs, and more guidance from our office. We are here to serve the folks of Illinois, not any one individual, but just the public at large. Our client is the state. We're here to protect the rule of law that sometimes we can take for granted, but that really matters, and that's why we do this work. So I do want to thank all of you folks again for letting us come and explain some of the work our office has been doing recently. So through all of this work, we seek to uphold the Constitution and the rule of law and to protect the state of Illinois and its residents. So that really is our guiding star for all of our work. And again, this work is really, really not about policy differences. It's much more fundamentally about protecting the legal system that serves us all in our country. So that really matters, and that must be protected. So again, I sincerely appreciate you folks having us here today, and just so we could share some of the work our office has been doing. We are thankful for your work on behalf of the state of Illinois and for the folks in Illinois, and I really appreciate your time today and for allowing our participation. So thank you all very much. Sure. How big is our staff? I actually am not the best source for that because I looked that up myself the other day, just because I had heard California's office was so big. I believe, and please do not quote me, and I know I'm being recorded, I believe we have about 300 attorneys. As to staffing decisions in terms of expanding, that is so far above my pay grade that I can't really comment on. But I will say that we had worked before the administration. I had a full docket. Back in December. So now I really have 2 dockets, just a lot more work. But it's a great place to work. Attorney General Raul is a fantastic boss. He really values us. And our office has really been a guiding star for, I think, the country as we've navigated these waters. But again, thank you all for your time. I really appreciate it.